two questions, both of which address the status of this rule as an emergency temporary standard. So my first question has to do with the question with which Justice Thomas opened, which is the meaning of necessary. So of course, when OSHA passes a rule through its regular regulatory process, it has to go through notice and comment, and that's a way of holding an agency accountable. All affected people have an opportunity to comment, and the agency develops a robust record. With an ETS, of course, the agency can circumvent that process so that it can act more quickly. So for an ETS, we would want that power to be the exception, not the rule. And one contrast that the applicants point out between OSHA's authority to issue an ETS versus a regular regulation is that for its exercise of power in the normal course, it need only find that a regulation be reasonably necessary, but for an ETS, it has to satisfy a necessary standard. Now, you've argued, and I think there's a lot of intuitive appeal to this, that when you're facing an emergency of the magnitude of this pandemic, that this power effectively can be used most effectively as a blunt instrument. You know, we don't have time to make industry by industry specific kind of calculations because we want to move with speed. But how do you reconcile that understanding of necessary with the broader reasonably necessary standard in OSHA's normal regulatory authority?
So we certainly agree that the emergency temporary standards reference to necessary as contrasted with reasonably necessary and appropriate is a heightened burden and includes a measure of tailoring that's necessary with respect to the particular mitigation measures. But I don't think that that helps the applicants here because they haven't come forward with any alternative mitigation measures that they think would equally protect the workers that OSHA found were in grave danger.
But do they have to come forward with that evidence, or did OSHA have to consider it and reject it? Because another part of their contention is that OSHA did not adequately explain why this measure, this particular rule in its scope, was necessary vis-a-vis or as compared to other possibilities.
Well, OSHA explained that at length over dozens of pages in the 150-page preamble to the rule. OSHA specifically explained why vaccination as the single most effective way to target all of the ways that the virus threatens workers in the workplace was a necessary measure here, and it further explained why masking and testing would be essential if workers remain unvaccinated in order to ensure that despite their higher risk level of contracting the virus, they couldn't carry it into the workplace and spread it to their coworkers. So I think the suggestion that this wasn't adequately explained is inconsistent with the arguments they're making. And as I understand their tailoring arguments, and this actually touches on the question you asked earlier in the argument, they're really focused on two things, the categories of workers and the particular workplaces. And they haven't suggested that there are other mitigation measures there that OSHA neglected to consider. They're saying those things should have just been carved out altogether. But that is inconsistent with the Secretary's judgment that all unvaccinated workers face a grave danger and that the risk exists anywhere that employees are gathered indoors together. And again, there might be subcategories within those groups that are in graver danger, but I don't think there is any basis on this record to conclude that the agency lacked substantial evidence to draw the lines that it did.
That's helpful, thank you. My second question is, again, about the status of this rule as an ETS. So Chief Judge Sutton pointed out in his dissent from the denial of initial en banc that OSHA did not adopt this rule in response to the emergency, qua emergency, because that had been ongoing since early 2020. But instead, it responded to new facts on the ground, which included the widespread availability of a vaccine that maybe it was a surprise many people chose to forego, and the emergence of the Delta variant. And Chief Judge Sutton pointed out that in an extended pandemic, or I don't know if we've moved to an endemic such as this one, facts will continually change. New variants will emerge. There might be new treatments, new vaccinations. We have boosters now, right? So now full vaccination might not just be the 2 jabs. It might include a booster as well. So when does the emergency end? I mean, a lot of this argument has been about Congress's failure to act. 2 years from now, do we have any reason to think that COVID will be gone or that new variants might not be emerging? And when must OSHA actually resort to its regular authority and go through notice and comment and not simply be kind of doing it in this quick way, which doesn't afford people the voice in the process that they're otherwise entitled to?
So I think if I could respond to that in a few different ways. Congress defined when the emergency exists. It labeled this an emergency temporary standard, but it's dictated by the statutory requirements. So there has to be a grave danger from a physically harmful agent or a new hazard, and the measures have to be necessary to protect against that danger. And we don't think that there's an additional free-floating requirement about emergency status that has to be taken into account.
So it could be an emergency 2 more years from now.
Well, I certainly take the point that the emergency can be of substantial duration. Of course, this is not a way to bypass notice and comment permanently. Congress further specified that the agency is expected to conduct a rulemaking process over 6 months, and that's why the agency estimated the lives saved, the hospitalizations prevented over the 6-month life of the rule.
Sure, but I was envisioning a new rule, right? Like, you know, OSHA might 2 years from now adopt something that's different from this vaccine or mask and test mandate. I'm just talking about the limits more generally on OSHA's power under the ETS provision.
The limits, I think, are the ones written into the statute. And so if you want to project out 2 years from now, I think it's entirely possible, of course, that the trajectory of the pandemic will change. I certainly hope so. And in that case, OSHA, I think, would have to, if it wanted to regulate again, cross the high burden of showing a grave danger. You know, this is an authority it has used sparingly in cases of what we think are true emergencies, and I think to suggest, based on concern about what might happen in the future, that its authority should be constrained or clipped now when we are in the middle of an unprecedented pandemic that is claiming more lives than we've seen in a shorter amount of time would do a disservice to Congress's anticipation that OSHA might need to act quickly in response to dangers like this.
Thank you.
Mr. Keller, rebuttal.
Two points, Mr. Chief Justice. First, we need a stay now before enforcement starts. Our members have to submit publicly their plans to how to comply with this regulatory behemoth on Monday. Vaccines would need to occur by February 9th. You would need 2 vaccines to comply. Those vaccines would have to start immediately. Tracking and record keeping cannot happen overnight. And on tests, you heard my friend, the Solicitor General, mention the media reports that we've all seen about shortages of tests and cost increasing. Our declarations, appendix page 345 and 374, confirm that as well. And that's exactly why workers will quit right away. You don't even have to take our word for it. The federal government, the Postal Service, and Amtrak both say the same things. What OSHA did is they cherry-picked one study about healthcare workers, a very specific industry, and what that worker attrition rate would be. Again, 2 declaration sites. We have plenty more, but appendix pages 351 and 374. And my second point to close on is about who decides in the public interest. And I would submit that this court's precedents answer that. We're not asking this court to reverse anything. Industrial Union 40 years ago, in Justice Stevens's controlling opinion, said that there was an absence of a clear mandate in the OSHA Act. So it's unreasonable to assume that Congress gave OSHA unprecedented power over American industry, and the emergency power is also narrowly circumscribed. Yet here OSHA has never before done mandated vaccines or widespread testing, much less over all industries or on an emergency basis. So whether we're talking about the agency's failure to explain, whether we're talking about the statutory term necessary, whether we're talking about how this has to be tethered to the workplace under the major questions doctrine, under any one of those theories, we are likely to succeed on the merits. And finally, when it comes to the public interest, as this court just recognized a few months ago, it is undisputable that the public has a strong interest in combating the spread of the COVID-19 Delta variant, but our system does not permit agencies to act unlawfully, even in pursuit of desirable ends. We would respectfully request a stay of this unprecedented sweeping ETS before Monday.
Thank you, counsel. The applications are submitted.